Hello everyone, welcome to Abhyaas Law Prep. This is part 2 of your important judgments, which is important for your 5YDC as well as 3YDC LLB entrance exam. So let's start with the first case of your part 2, that is Minerva Mill versus Union of India. In this case, the 42nd amendment which have happened, which is also known as your mini constitution, came up with many changes. It also said that your parliament has wide range of powers to amend your constitution. We remember what do you mean by amend? That is to change. So in your 42nd amendment, they also said that they also made a change that parliament will have uncontrollable, that is absolute right to change your constitution. And it also said that DPSP is superior over your fundamental rights, which means your directives, principal state policies are more important than fundamental rights, was being said in your 42nd amendment. This is your facts. Now coming to the question, the main question in this judgment was, can your parliament have unlimited power to make any changes or to make any amendment in your constitution? So the judgment said that parliament's amending power is limited. They can't change everything in your constitution. It is limited. And they also said that we should have harmony between fundamental rights and DPSP, which means fundamental right is not superior, neither DPSP is superior. They both should go hand in hand. Here they also said that no organ is above constitution, which means organ in a sense you have three organs, right? Legislative, executive, judiciary. Neither of them are more important or superior to your constitution. In India, constitution is superior to everyone. Now coming to your Indira Nehru Gandhi, that is Indira Gandhi versus Raj Narain case. Here the facts, let's coming to the background of your case. Your Allahabad court have said that Indira Gandhi's election was manipulative. In a sense, she have used some manipulative sources to win that election, so that election was set aside. In a sense, we treated it as not valid or void. So here to escape this judgment of Allahabad High Court, your Indira Gandhi have made changes in parliament. In a sense, she made a change in constitution saying that your MP's election, your PM's election, that is your Prime Minister's election, will not go for judicial review. When High Court is talking about election, she just made a change in constitution saying that your courts cannot interfere in Prime Minister's election and it will be dealt separately by Parliament, some committee formed by Parliament. So here the question is, can election related dispute can be kept outside your judicial review? As we all know, judicial review is part of our basic structure. So the question raises here is, can your election be kept aside out of your judicial review? So here the judgment says that the amendment what was made is invalid, it's unconstitutional, and free and fair election is part of your basic structure. As we said, judicial review is part of basic structure. Your free and fair election is also part of your basic structure. Here we also, the important point we can note down is, democracy cannot be destroyed. The essence of this case is that democracy cannot be destroyed by any means. Now coming to ADM Jabalpur versus Shivkant Shukla, this case is also known as Black Judgment of India. In this case, the facts are like, during your emergency, we know, right, whenever there is some external war like situation, some internal conflicts, your center government have right to implement emergency, wherein center will be powerful and our fundamental rights will be suspended. So during your emergency, during Indira Gandhi's time, many people were detained. What do you mean by detained? Arrested. Without any reason. There was no justification given. Like if someone is arresting you right now, in a sense your police officer, they'll say you, this is your crime or this is your wrong, this is the reason we are arresting you. But whereas coming to your emergency time, many people were detained without any justification, and Shivkant Shukla have filed habeas corpus writ. What is habeas corpus writ? Whenever you are detained, arrested or restricted without any reason or without any justification, you can file habeas corpus writ directly to Supreme Court or High Court. But this writ was not heard. So coming to the question here, we are saying that can you detain a person what they are saying, can a person be detained during emergency, and can they seek liberty? In a sense, can they approach the court? So here judgment says that court denied the relief and allowed suspension of liberty. Your Article 21 was violated, which means you can't file for habeas corpus writ. And it is also known as your darkest judgment, where the Article 21's ambit, right to life and liberty, was more narrowed down. Till now, this judgment is criticized. That is your ADM Jabalpur versus Shivkant Shukla. Now coming to Champakam Dorairajan versus State of Madras. Earlier what we have seen that your fundamental rights and your DPSPs are equal. They are harmonious. But whereas coming to your Champakam Dorairajan, they said something quite opposite. So coming to facts, there was reservation order, that is Madras communal reservation order challenged. And here the question was, can your state reservation on basis of community or your caste can override your fundamental rights? What is overriding? Can violate your fundamental rights. So here judgment was given that fundamental rights will prevail over DPSP. What is prevailing? That will give more importance to fundamental rights rather than your DPSPs. Then coming to Shah Bano case, this is also, if you know the movie Haq, the movie Haq is based on this case, that is Shah Bano case, which is a landmark judgment in Muslim women's rights. Here the lady, that is Shah Bano, is divorced by the man. He was advocate and he gave triple talaq, and she demanded maintenance from her husband. And at that time it was challenged that Muslim women usually after iddat period, after the waiting period, they can't claim for maintenance. So here the question arises that can Muslim women claim maintenance under CRPC? That is your section 125 of CRPC, where usually your Hindu women's claim maintenance for. So here judgment given was that yes, she is eligible for maintenance. Here they said that we shouldn't discriminate on basis of religion, that every woman should get this right under section 125, and they say that if we are not giving them maintenance under section 125 CRPC, then it is violation of their fundamental rights. This is a major case on women's right and personal laws. It can also be treated as major landmark judgment in Muslim women's rights. Now coming to Sarla Mudgal versus Union of India. In this case what happened is, usually many men, some of Hindu men used to convert into Islam just to remarry. So after facing this problem, after getting many petitions on this, what happened is, the question was, can conversion can be used for your monogamy? Because they used to think that if we'll convert into Islam, we need not to divorce our first wife and we can get married to second wife and we'll not be criminally liable. We have done nothing wrong. But the judgment says that such second marriage will be invalid, and the courts also stressed on the part that we should try to impose UCC, Uniform Civil Code is nothing but where the civil laws or family laws should be same for everyone in India. Now coming to your Navtej Singh Johar versus Union of India, it is one of the most important cases. Here section 377, which says that same-sex relationships are criminalized. It is not right or it is unconstitutional, used to be said in your 377. But the question came in at the time when the case was filed. They said Is not your section 377 violating our dignity? Is not your section 377 violating our equality? Why don't we have right to choose our own partner? Why don't we have right to dignity like others? So the judgment says that the consensual homosexuality is not a crime. It is decriminalized. You can be in relationship with same-sex partner and it will not be treated as a crime. Previously, if you know, before it was being abolished in 2018, it used to be treated as crime and people used to be imprisoned for this. So this is a major landmark judgment for your LGBTQ rights. Coming to Joseph Stein versus Union of India, it talks about adultery. If you know, adultery is nothing but your extramarital affairs. Usually whenever there was a case where you see extramarital affairs, the second person, if I'll explain you, A, B and C. A is husband, B is wife and C is third party man. Third party man. Then A can file complaint on C because he, without permission, without taking any permission from A, husband, have been in relationship with his wife. They used to treat usually before that your woman, that is your wife, is property of husband and the third person without his permission is in relationship with wife. So they said that this is actually where you're treating women as an object and this particular law is being made just to control women. That is what they said. And they said just criminalizing the third party, that is man, is also wrong, because when they both are in relationship, when they are both in consensual relationship, why only man should be punished and not women? That was also in debate. So here they said that is adultery really a criminal offense? And if we are treating it as criminal offense, is it constitutional? So judgment said that adultery is not crime, it is decriminalized, and the importance here we gave it as marriage is not control over women's autonomy. And point to be noted, right now adultery is not a crime but it is a ground for divorce. If you want to file a divorce, if your partner is in extramarital affair, then it is a valid ground, but it cannot be criminalized. Now coming to NALSA versus Union of India, this is important case for your recognition of transgender person. And the question here was, do transgender person have constitutional identity and equal rights as us? So the judgment says that, your Supreme Court judgment says that transgender is identified or recognized as third gender. If you see, whenever you are filling some form or anything, you will be seeing three genders, male, female and third, others. So that is your third gender. The importance, what importance we got from this judgment was, the third gender people have got this right to dignity and they also got right to equality. Now they can right to self-identification is protected in a sense. They need not to go and approach some hospital or MRO to say that I am a third gender person. That is on basis of self-identification as per NALSA's judgment. Usually you even have your third gender reservations and it is solely on basis of self-identification. But right now you need to also search for your transgender act, the recent one, and relate it with NALSA. You might get into, you might to know that NALSA and Transgender Act are contradicting because of the medical examination and all. Please even look into it that, because for your current affair it will be important. Now coming to your Olga Tellis versus Mumbai Municipal Corporation. Here it is revolving under your Article 21 and the facts of the case is like pavement dwellers. The usually people shop what you say, who have stalls on roads, the small bundis you say, right? You see the fruit vendors, something like that. They were removed from the streets of Mumbai and the eviction was challenged. If you know, in Hyderabad right now, because of Hydra, many of the small stalls are being removed and demolished. Something like that you can say. So here question was, this eviction, this removal of these pavement dwellers, is it violation of right to life? Your Article 21's violation. So here judgment held that right to livelihood is part of your Article 21. Right to live also includes right to livelihood. So here they are saying life, right to life and liberty law, life is not only just existing like animal. This point is important. In this case, they have clearly said that Article 21 में the word life doesn't means just existing like animal. We also have other rights under right to life and liberty. Now coming to Romesh Thapar versus State of Madras, it is talking about your Article 19A, freedom to speech, and your publish as well. So here Madras government have said that the political journal of Romesh Thapar should not enter into your Madras, and it should not even circulate in Madras. So it was total ban on this political journal of Romesh Thapar. And the question here was, can state suppress publication and circulation? When we are saying in Article 19A we have right to speech, right to expression, then why this political journal was banned in Madras was questioned. So the judgment said that freedom to speech also includes freedom of press, which means freedom of publishing, freedom of expressing. These all comes in one, that is 191A. Now it is your national anthem case. It is also known as your national anthem case. Here, the Jehovah community students refused to sing national anthem because in their faith, they don't sing any other songs apart from their religious songs. So here the question was, is it punishable? Is it disrespectful? These students were expelled from school. They were removed from school because they were not singing national anthem. So here the question is, can students be punished for the respectful silence? They were standing, actually they were standing, but they were not singing, they were silent. So the judgment says that freedom of consciences is protected under your Article 19 and Article 25. Article 19, freedom of speech also includes freedom of being silent, as been said in this judgment. And they also said that Article 25, which talks about your religion, right to preach your religion, right to propagate your religion, it is that to remain silent and not to sing national anthem is protected under Article 19 and 25. So here importance of this judgment is that respect for anthem does not means forcefully singing. Here they said even if you're standing respectfully without singing national anthem is fine. Now comes A.K. Gopalan versus State of Madras. So it is narrow downing your Article 21, right to liberty, that is your right to life and liberty. Here there was a leader, A.K. Gopalan, communist leader A.K. Gopalan, who was detained under Preventive Detention Act. So here he was arrested under Preventive Detention Act, and here the question was that what is meaning of personal liberty under Article 21? So in this judgment, court gave very narrow judgment of personal liberty, whereas in Maneka Gandhi case, that is Article 21, they gave very wide judgment. They said right to life also means right to moving abroad or right to going abroad. So here, right to travel abroad. So here in your A.K. Gopalan, it gave very narrow judgment, but in Maneka Gandhi, quite opposite, they have widened the judgment. So these were your top important judgments for your LAWCET exam. Now I'll be coming up with more similar videos for your law of torts, your law of contracts, and one MCQ solving series. Till then, be updated and please follow. If you like this video, like, share and subscribe.